Hello, everyone, and welcome to our webinar, Pensions and Benefits Look Forward and Look Back. I'm Michael Wolpert, a partner at Fasken and the leader of our Pension and Benefits Law group. I practice exclusively in pensions and benefits law, advising private and public sector clients on plan governance, regulatory compliance, and the pension and benefits implications of business transactions. And throughout my career, I've also been closely involved in pension law reform initiatives across Canada. Before I introduce our panel today, I'd like to draw your attention to a few administrative items shown on the screen. Please note the CPD certificate and post-event survey. QR codes and links will be shared at the end of the webinar so you can complete the survey and access your CPD certificate for Ontario, Quebec, or BC. And we'd really appreciate you taking a moment to share your feedback. So we have a great group of Fasken speakers joining us today. I'm going to introduce them quickly now. Rhonda Grintuch, a partner in our Labor, Employment, and Human Rights group in Montreal. Rhonda works closely with pension and benefits teams, advising employers on workplace issues that intersect directly with pensions, including executive compensation, benefits arrangements, and employment-related risk. She also represents clients in employment disputes and brings a practical perspective to navigating the Quebec employment landscape. In addition, I'm pleased to introduce Dominique Monet, also a partner in our Labor, Employment, and Human Rights group in Montreal. Dominique advises clients on the full life cycle of pension and benefit plans, including governance, administration, and regulatory compliance, and has significant experience helping organizations manage complex pension issues and evolving legislative requirements. And from there, we're going to head west, and I'd like to introduce my Calgary colleague, Lindsay, an associate in our pension and benefits group. Carter works with clients on a wide range of pension matters, including plan design, governance and compliance, and regularly advises on the pension and benefits aspects of corporate transactions. Carter provides practical guidance to clients navigating an increasingly complex regulatory environment. And last but not least, heading east again, I'm pleased to introduce Johnny Wypych, also an associate in our Pensions and Benefits Law group in Toronto. Johnny advises both private and public sector clients on pension plan governance, administration, and compliance, and supports clients throughout transactions and other complex matters where pension considerations play a key role. So now let's start our presentation, and over to you, Johnny.
Thank you so much, Michael. Today, I'll be giving you guys legislative and regulatory updates along with my colleague, Rhonda. I'll be focusing specifically on the federal government's recent announcements, BC, Alberta, Saskatchewan, Manitoba, and Ontario. So first, starting it off, we'll first be examining what federal updates have come out. A material one was in August of 2025. The Department of Finance released a proposed technical amendment to the Income Tax Act. It, at this point, really focused on four main things. The first one is transfers from registered plans to unclaimed property authorities for unlocatable individuals. In this rule, the proposed rule would let an RPP administrator transfer an unclaimed pension entitlement from an unlocatable individual to an unclaimed property authority without triggering the immediate tax to the member at the time of transfer. The explanatory note issued along with this says that the amount paid or transferred from the RRP to an unclaimed property authority would be excluded from income at that specific time. So in practical terms, instead of the pension holding the small unpaid amount forever because it cannot find the member, the plan would transfer the gross amount to a relevant unclaimed property body, and the tax would not be triggered at that specific time. The next one that came out was new rules around orphan employees and legacy benefits. So the proposed orphan employee rule deals with a DB plan member whose original employer has stopped participating in the plan for ongoing accruals. The problem is that the plan may still have legacy DB liabilities for those people, but the normal tax rules may not permit them to make up for any deficiencies. So there was ongoing discussion about how to deal with this. The next one is tax deferred for certain annuity commutation scenarios. So this deals with a situation where an RPP previously bought for an annuity for a member. Normally, once an annuity exists, the tax rules do not automatically treat later money coming out of that annuity as it still is coming in from the pension plan. The amendment addresses specific cases where the annuity is commuted or surrendered, such as a marriage or a common law relationship breakdown. And then finally, specific rules about prohibited investments. rules and related parties. This is a relatively technical change and relates mainly to financial institutions that both act as the plan sponsor and administrator, and also use their platforms to invest. Perfect. We also had a variety of benefit changes relating to federal employees. The first one was the remove paid pregnancy loss leave for standard hours and averaging period of calculation. We also got clarity on how pregnancy loss is treated in special payment calculations, in addition to how it's dealt with in multi-employer purposes. The revised record-keeping obligations for pregnancy loss and bereavement leave was also updated and provides greater clarity to employers on how to deal with this in the event that their employees find themselves in this situation. Can I have the next slide, please? And similar to typical federally regulated employees, similar obligations or similar entitlements were added for those who are deemed as interns. I think I've lost ability to change the slides. Okay. In addition, we're now moving from the federal sphere to British Columbia. So British Columbia created a new unpaid serious illness or injury leave. Under this, eligible employees may take up to 27 weeks of unpaid leave with a 12-month period due to serious personal injury or illness. Next slide. On the pension front, the BEC regulator came out with additional guidance on how to deal with the supervision of pension plans. So the BCFSA came out looking specifically at funding risk, investment risk, governance risk and operations, and business and plan sponsor risk. The regulator also says it may capture other risks where appropriate. So the 4 categories that it outlined are primary and not meant to be focused. There is a tiering obligation. So BCFSA assigned each pension plan a tier rating on a scale of A to E. The tier rating is based on assets and membership size. Next is risk rating. This is out of 1 to 5, and it looks at low risk being 1 and high risk being 5. And then finally, the stages. So they assign stage ratings from 0 to 4. The stage rating reflects the plan's risk profile determined on the urgency and intensity of the specific risk. Again, the main takeaway here is that CAPSA has also released out guidance on how to deal with risks. And what we're seeing from regulators is that they're really expecting documentation of different risks that might be applicable to a plan and how exactly the plan administrator is considering those risks. In addition, we also received BC's information security guidelines. Again, not much new here from what we've seen within CAPSA and their risk guidelines, but again, a greater emphasis on how information security is being dealt with in a plan administration and really what the monitoring process has to be when ensuring that your policies are up to date. A key one, and one that we're actually having a difficulty time negotiating with different service providers, is really the expectation to report to the regulator. They note that their expectations is 72 hours if it's a material incident. Again, this is becoming an ongoing struggle in negotiations, but really we have some good, clear guidance from the regulator on what they expect. Next slide. You can actually flip to the next one because this is all going together. BC, similar to how Ontario did a few years ago, released a roles and responsibility guideline summarizing their expectations for plan administrators. So this outlines your basic expectations about administrator duties, fiduciary obligations, governance, service providers, funding, etc. It's a very helpful guide for BC regulator or for BC pension plans because it really is a consolidation of a variety of different guidances and does provide a clearer outline of what the BC regulator is expecting in respect of administering your pension plan. Just a few additional ones. Now moving to Alberta, we have effective this year, the maximum unpaid leave increased from 16 weeks to 27 weeks. So that is helpful information from the Alberta government. Next slide. We also saw that Alberta introduced meaningful annuity and wind-up reforms. Michael, my partner, will be speaking about this in greater extent later on. But to the extent that we now are seeing a statutory discharge qualifying for buyout annuities in Alberta, something that we've had in Ontario for quite a long time, in addition to extended temporary absence periods from 52 weeks to 78 weeks, and required annuity purchases for members who are already on a DB plan wind-up. Given the time, I'm going to just flip over for a few more slides. Right here. So just on the Ontario side, we have seen some interesting developments in the last budget. So Bill 97, Planning to Protect Ontario Act, did receive royal assent on April 24th. The bill spoke in greater detail about variable life benefits for DC plans and plans with AVCs and just how those can be converted into variable life benefits. We did get interesting regulations that are going to be coming through on conversion of a JSPP or an SEPP to a JSPP, specifically when it's a DC plan, and how DC plans can not only join JSPPs on a future service basis, but also integrate their assets and buy back. Interestingly, we saw the PBGF guarantee increase from $1,500 to $3,000, yet the actual fee for the PBGF did not increase. And then finally, we got some guidance that will be coming through in regulation on how to deal with unlocatable members. In short, if the individual is over 100 years old and the plan administrator has gone through a specific process to try to locate them, then there is a process for how you can deal with those assets. In the DC context, it can be used to pay for DC costs of administering the plan, and in the DB context, it can revert back to the remaining members. I'll now pass it on to my colleague Rhonda to continue.
Hello. So you can advance to the next slide, please. I'll dive into the Quebec legislative and regulatory changes, and then we'll head eastward to the Atlantic provinces. So in January 2026, Quebec's variable payment life pension framework came into force. And as a reminder, this relates to Bill 80, which received royal assent in December of 2024. And that brought amendments to the QSPPA and Voluntary Retirement Savings Plan Act. Some of the key rules introduced under Bill 80 were the following. So eligibility is as of age 55, unless the plan provides otherwise. Segregated fund requirements. The bill specified that payments must come from a separate variable payment life pension fund within the plan. There are specified payment options, including a 10-year guarantee option. And then there are rules on specific events, such as upon termination of the plan, employer withdrawal, and wind up of the VPLP fund. So while Bill 80 in 2024 established the structure, it left much of the operational detail to regulation, which have now come into force in late 2025. If you could advance to the next slide, please. The regulatory regime was adopted or assented to in December 2025, and then came into force on January 1st, 2026. And this brought amendments to the Quebec regulation respecting supplemental pension plans and the regulation respecting voluntary retirement savings plans with respect to variable payment life pension funds. So here the regulatory regime comes and fills in the administrative, funding, and governance details. Some of the key aspects of note, the regulatory regime adds financial reporting requirements specific to each variable payment fund. Also, there's an introduction of penalties for failing to file the required pension adjustment reports. There are plan text requirements which specify what must be included in the plan text regarding operation of the variable payment fund and participant rights and options. There are payment rules which establish the method for calculating variable payment life pension amounts. There are rules relating to member communication. So pension committees must provide specific prescribed information to members and beneficiaries. And there are rules on transfer and wind up governing transfers in and out of the fund and termination of the variable payment fund. So with Quebec's VPLP framework, it has become the first province to establish a regulatory framework that permits the implementation of dynamic pension funds. Plan sponsors will now need to decide whether to offer the VPLP option and amend their plan text accordingly. You can advance to the next slide, please. So another Quebec update relates to the Act respecting labor standards. This came into force in October of 2025. The amendments add a new unpaid leave for public health or public emergency, where employees are unable to work due to a recommendation, an order, or a direction under a public health or emergency law. The leave is for an unlimited duration. But employees must take reasonable action to limit the duration of the leave. And like other statutory leaves of absence, employees on this type of leave have the right to reinstatement at the end of the leave. Another amendment expands the reservist leave for reservists who are called to military service. The job protected leave now includes the period of medical treatment and rehabilitation post military service, and the job protection rights now cover those periods post-service as well. And now we'll move to the Atlantic provinces. In April 2025, Nova Scotia adopted targeted pension reforms to give members more flexibility in accessing locked-in retirement savings. So most notably, individuals can now unlock up to 50% of their funds at age 50, as of age 55, when they transfer to a life income fund. The reforms also expand access in cases like shortened life expectancy and non-residency. The province also simplified life income fund rules by removing temporary income provisions for newer accounts. At the same time, these legislative reforms strengthen governance by requiring biennial statements for former and retired members. Next slide, please. Another update here for Nova Scotia. The province has strengthened somewhat its domestic leave regime by increasing the paid portion of the leave from 3 paid days to now 5 paid days. Next slide, please. Onwards to New Brunswick. On June 6, 2025, Bill 12 was assented to and repealed the Pension Plan Sustainability and Transfer Act, which had been passed by the earlier New Brunswick government. So this signals a reversal of the implementation of the prior framework that forced certain public sector plans to convert to shared risk models. Next slide, please. Another update for New Brunswick, Bill 15 was assented to in December 2025. This introduced targeted flexibility for certain pension plans by allowing some MEPs and fixed contribution DB plans to make benefit adjustments without triggering the void amendment rule. It expanded the circumstances where commuted values can be paid or transferred, including unclaimed amounts. And it provided relief for some of those same plans that I mentioned from strict wind-up funding payment obligations. Next slide, please. On October 22nd, 2025, the Financial and Consumer Services Commission issued revised guidance on the statutory discharge of annuity buyouts. The updated guidance refines the conditions under which the plan administrator can obtain a statutory discharge following an annuity buyout. There's a particular focus on what should be included in the notice of the purchase sent to affected individuals and the funding test that should be met. Note that the updated guidance indicates that additional parameters may be introduced in future regulations, so we will stay tuned. Next slide, please. Moving on to Newfoundland and Labrador, Bill 6, an act to amend the Pension Benefits Act, received royal assent just earlier this month. The key changes involve clarifications of the solvency framework. So it introduces statutory definitions of solvency assets and solvency ratio, which provide for clearer rules for assessing plan funding on a wind-up basis. And it enables transfers of pension assets to plans outside of the province in other Canadian jurisdictions, subject to regulatory approval and solvency thresholds. Next slide, please. Thank you. The last update here that I have for you is the CAPSA update. So CAPSA added practical operating rules for how regulators will administer on a day-to-day basis the 2020 agreement respecting multi-jurisdictional pension plans. The new administrative procedures came into effect on January 1st, 2026, and are designed to facilitate the implementation of the agreement. The administrative procedures clarify things like who makes decisions, how appeals work, how disputes between regulators are handled, how regulators coordinate with one another, what language and reporting conventions apply, and as well as when administrators are notified if minor authority acts, and what happens if to pending matters if a plan's major authority changes. Next slide, please. So I will now kick off the case law portion of the conference by presenting a case that was successfully pleaded by none other than Monet.
Thank you.
Who will be the next speaker.
Thank you, Rhonda.
So in an award that came out in February 2026, an arbitrator, this is the Sobeys in case, the arbitrator dismissed a grievance filed by the union against Sobeys, which contested plan enrollment dates. The union challenged the enrollment dates in the pension plan for 32 plan members who had voluntarily joined the plan between the late 1980s and early 2000s. This was under successive employers before Sobeys acquired the operations in 1998. And the pension statements issued over the years showed the enrollment dates. However, the union later compiled the data around 2017 to 2019 and identified apparent inconsistencies when comparing the dates in the compiled data with the eligibility criteria. So the grievance here alleged that the recorded enrollment dates were incorrect and they were less favorable to employees, and the union sought corrected dates or equivalent damages. The employer disputed both liability and the union's ability to prove the corrected dates. Sobeys here raised several preliminary objections, arguing that in the first place, the grievance itself was time barred under the collective agreement's 28-day mandatory filing deadline, and that it could not be held liable for enrollment decisions made under expired collective agreements by prior employers. Next slide, please. So in the result, the arbitration tribunal declined jurisdiction. The arbitrator upheld the employer's preliminary objection and declared the grievance to be time barred or prescribed, as we call it in Quebec, and dismissed the grievance. The arbitrator reasoned here that the pension plan is an integral component of the collective bargaining agreement if the plan is explicitly referred to in the CBA, which it was in this case. The CBA also had a strict filing deadline of 28 days from the date of the underlying incident. So the decision here highlights several important points. The limitation period starts to run when each employee receives their individual first annual contribution statement showing their enrollment date, not when the union later compiled the data decades later in 2019. Another point raised in the decision was that this was not a continuing grievance because the enrollment dates were fixed events in time and not a recurring violation. In addition, it found that employees bear primary responsibility for verifying enrollment information on their plan statements and for raising concerns to their union in a timely manner. And finally, the successor employer transfer rule under Section 45 of the Quebec Labor Code cannot serve to revive a right that has already been extinguished by prescription. I will now hand it off to Dom for further case law updates.
Thank you, Rhonda. That was quite an extraordinary presentation.
Thank you, Dom.
Of the Sobeys case. So I would like, next slide, please. I would like to talk today about two very important cases that have come out of Quebec, one in 2025, one in 2026. Both deal with liabilities of either the administrator or the plan sponsor. The first case is Bernard versus the Montreal Police Retirement Association, which was rendered on March 28, 2025, dealing with portability and the administrator's liability. And the second one is Milliard versus Kraft Heinz, which was rendered on April 9th, more recently, 2026, on a change of design from DB to DC. In fact, it was a wind up of a DB and then a migration to a new DC, and the sponsor's liability in this regard. In the end, we'll see that in the first case, the administrator wins, that the administrator escapes liability, but that the sponsor does not in the second case is found liable. Also, in both those cases, what is interesting is that the role of the regulator, because in both cases you had a regulator intervention, and it's the court clarifies what the role and responsibilities of the regulator in each area that's involved in the cases. Next slide, please. So the first case, Bernard versus the Montreal Police Retirement Association, deals with a member, a police officer of the plan, who resigned in November 2019 and asked for the transfer of his commuted value. So he hadn't reached the age of 55 and wanted to transfer exercise his portability rights. This was done on March 9, 2020, because he had originally opted for the transfer of his commuted value in February 2020. But the rules here required that it be done in person. So the pension committee insisted that he show up in person, and he did on March 9, 2020. And therefore, this triggered the 60-day statutory period to do the transfer of commuted value. And in the meantime, what happens is a thing that many of us might recall, COVID-19 happens. And Quebec, as other provinces, declares a state of emergency on March 13, 2020, precisely during that 60-day period, during which the commuted value has to be, the law says that the pension committee must deal with the transfer of the commuted value. So that 60-day period would have ended on May 9th, 2020. So 60 days from March 9th, 2020, May 9th, 2020. Next slide, please. However, in the meantime, so in April, Retraite Québec, which is the Quebec pension regulator, issues a bulletin advising all plan administrators in the province that they should henceforth transfer commuted values based on the preceding month solvency ratio rather than the solvency ratio of the last actuarial valuation. In this case, because COVID had a negative effect on markets, etc., the plaintiff, Mr. Bernard, lost because of this bulletin. He stood to lose, and in fact, he did lose 50% of his commuted value because the regulator was now directing or issued a bulletin to administrators that they should use the solvency ratio of the preceding month. Next slide, please. So this obviously upset Mr. Bernard considerably, and he took legal action against the pension committee in damages. And in fact, his case, which is an interesting argument, was that he had entered into a contract with the administrator that because he had selected transfer his commuted value and there was an obligation to deal with that within 60 days, that there was now a contract as of March 2020, so before the bulletin, to transfer that amount as confirmed during the in-person meeting. And that Retraite Québec can issue bulletins and give advice to pension administrators, but they're not binding, and they're not binding on the plaintiff, and they're not binding on the plan either, given that there's a contract. So that argument was dismissed, and the court held that there was not a contract, that in fact pension law is a specialized and highly regulated field, and that you can't import common law or civil law concepts into the equation. Also, with regards, next slide, please. Also, in regards to the bulletins issued by the regulator, the court ruled that the administrator, in its fiduciary capacity, had to take into account the bulletins that were issued by the regulator, and it was reasonable and prudent for the administrator to follow the advice of the regulator as expressed in the bulletin. Next slide, please. So, excuse me. So, the next case, Milliard versus Kraft Heinz, is a class action by more than 300 former members of the Kraft DB pension plan. This was a classic DB pension plan set up in the early 70s, and it was wound up on December 31st, 2016, to be clear. And it was wound up following the merger of Kraft and the Heinz Company. Kraft had previously, this is important, Kraft had previously notified all the DB members 3 years earlier that the plan would be wound up effective December 31st, 2023, not December 31st, 2016. Next slide, please. So in fact, it had given originally a 10-year period to the DB members, and in fact, in the correspondence and in the literature, it had mentioned to members that it was to give them sufficient time to study their retirement and investment option, and also told the members that the wind-up in 10 years would not affect any retirement or cessation of employment occurring before January 1st, 2024. So these were representations that were made to all the members of the plan, and it's a 10-year notice of the wind-up. What happened is that after the merger and the new company, the successor company, now decided to in effect advance by 7 years the wind-up. So now was informed them in November 2015 that in fact the wind-up would occur on December 31st, 2016, instead of December 31st, 2023. So that's advancing it by 7 years. Next slide, please. The termination report for the wind-up, 2016, December 31st, 2016, the termination report was sent and approved by the Quebec regulator. Now, this is a bit complicated in the sense that is it really an approval or not by the regulator? Here, the law may be a bit different with Ontario. In Quebec, the regulator can always send back an actuarial evaluation if it's not happy with something in it. Whereas in Ontario, I think there's a formal approval. But the point in this case is that the bridge benefits. So the bridge benefits, which is the special pension paid to early retirees to tie them over to age 65 so that they can receive their state-funded pensions at 65, that the bridge benefit, there was no calculation made in the termination report for the bridge benefits of any member who did not attain age 55 and retire by December 31st, 2026, a new wind-up date that, you know. And in the course of their employment, these employees, the affected employees, could opt into purchasing bridge benefits. And they had an option where if they paid extra contributions, they could receive a bridge benefit. And the class action is predicated on the fact that many did so on the basis that the plan would wind up in 2023. Not in 2026. Next slide, please. 2016, sorry. Thank you. So this is a very interesting decision. I think it's a major decision. It covers many different topics. One of them is the termination report and what is the effect in Quebec and perhaps in the rest of the country as well, in other provinces, of the termination report. The court found that here the termination report is not in effect a decision of the regulator. It does not bind the members. The members are not a party to the termination report, and that therefore the fact that the regulator had not included the benefits did not bind the members. And under We also have some interesting comments there. You've seen B and C on bridge benefits, saying that they're not something normally that accrue with time as a normal pension. But in this case, and I'm conscious of the time here, I'll just go quickly to the conclusion. So next slide, please. That in this case, the court ruled in favor of the plaintiffs on the basis of the initial representations made by Kraft that the plan would wind up on December 31st, 2023. The court found that it was abusive and illegal for a sponsor to backtrack on a 10-year notice like that, and on the representations that were made at the time of the 10-year notice without breaching its good faith obligations. Next slide, please. So the plan promised to pay a bridge benefit is a condition, is considered a conditional obligation under Quebec civil law, the Quebec Civil Code. And the employer, when you have a conditional obligation, an obligation that arises as the result of a condition, the debtor cannot unilaterally frustrate or prevent the condition from occurring. So all plaintiffs aged 55 or more were entitled to the commuted value of their bridge pensions. And there was also an issue in the case about releases, and that the release was not sufficient to bar the claim. So that terminates my presentation. Thank you. I will now pass it over to Carter Lindsay. Thank you.
Thanks, Dominique. Hi, everyone. I'm going to continue with some case law updates and some legal issues to watch across the remainder of Canada. From the onset, I'd like to note that there hasn't been a lot of case law related to pension and employee benefits in the last year. However, the common issues that we are seeing are consistent with those that have been raised in the past years. On this basis, we've chosen a few cases to highlight some of these common issues and the circumstances in which they arise. I'll start with a few pension-related cases and then move on to some benefit ones. Next slide, please. So the first case we have for you is Derise in the city of Ottawa. This is a Human Rights Tribunal decision which involves a dispute by Ms. Derise, a longtime employee of the city of Ottawa, as to her pension entitlement. Derise claimed that in the 1990s and early 2000s, her employment status had changed various times to accommodate her raising children. And then in 2009, Ms. Derise was offered the opportunity to buy back her pension. She took this opportunity believing that the buyback would give her the same pension entitlement that she would have had she not altered her employment status to raise her children. Later, Ms. Derise realized that she had only bought back about 18 months of her pension as opposed to the full 41 that she had thought she was buying back. Further on in the future, in August of 2023, and in the wake of the Fraser decision, Ms. Derise filed an application stating discrimination on the basis of sex and family status as it related to her pension buyback. The tribunal dismissed this application on the basis that the issue of the pension buyback arose in 2009 and that they had ample time and notice to review what her entitlements were. While this is somewhat focused in the procedural aspects of administrative law, this case shows that early communications matter, and that when there is a delay in taking action, that delay can be fatal to the member when they had enough information to raise the issue earlier. Next slide, please. The next decision we'll be discussing is DCL Corporation. So in 2005, DCL Corporation, or DCL, was in DCAA proceedings. At the time, DCL sponsored 2 defined benefit pension plans, of which FSRA ordered to be wound up. When the wind-up reports were approved by FSRA, it was determined that both plans had a surplus. In the wind-up report, it stated that the surplus would be allocated in accordance with the governing documents of the plans or as otherwise determined by the court. The monitor for DCL stated their intention to bring a motion regarding the surplus entitlement, and the court appointed counsel to represent the plan members. Counsel to the plan members formed a committee comprised of plan members, and that committee was in charge of negotiating the members' entitlement to surplus with the monitor. The members and the monitor came to a settlement in which the net surplus between both plans would be shared 45% to the members and 55% to DCL. Next slide, please. So the Ontario Supreme Court approved the settlement agreement on the basis that the monitor had authority to pursue this compromise, that the agreement fairly balanced stakeholder interests, and that the alternative being 1, FSRA making a determination based on the plan documents, and 2, a vote by the members to approve the agreement would take several months and possibly require plan documents that no longer exist. The court recognized that under the Pension Benefits Act, a vote of 2/3 of the members would normally be required to give effect to the surplus sharing arrangement. However, the court found it also had the requisite authority to approve the negotiated settlement. This case shows that surplus entitlement remains a live issue, but also that in an insolvency context, negotiated surplus sharing agreements may be approved by a court. Next slide, please. This next decision, it toes the line between pensions and benefits, and it can be applicable to both. It's an arbitration decision dealing with the interpretation of top-up provisions in collective agreement and the limits of what a make-whole remedy can be, particularly in the context of workers' benefits, pension contributions, and extended benefit coverage. At a high level, the case deals with a particular question of when an employee is receiving statutory disability benefits, to what extent can the employer adjust those top-up obligations based on the income they're deemed capable of earning elsewhere. In this decision, the griever was a police officer and had been unable to work due to PTSD since 2017. She was approved to receive WSIB loss of earnings benefits up to 80% of her salary, and then under the collective agreement, the employer had an obligation to top these benefits up so that they would receive their full net salary. Based on this arrangement, the employee was compensated until they were terminated until January 2020, and then they were terminated for frustration of contract. Importantly, the officer did not discover termination until 2022. They had filed this grievance later in the year, and then the employer ultimately reinstated the officer in 2023, but only partially resolved the compensation issue. Simultaneously, WSIB had determined that the officer was capable of working in a different occupation, specifically a social services role, and assigned her imputed income based on that assumed earning capacity. The employer then used the imputed income to determine the top-up payment, which significantly lowered the officer's actual received compensation. Next slide, please. The arbitrator agreed with the union and found that there was a breach of the collective agreement, the reasoning being that the provisions of the collective agreement said that the employee would receive WSIB benefits, the difference between the WSIB benefits and their net regular salary, and that there was nothing in the collective agreement to reduce their salary based on the income actually earned or the income they could earn. This decision highlights the interplay between collective agreements and pensions and employee benefit plans. Next slide, please. In terms of pension legal issues to watch, there's 5 that we wanted to highlight for you. These have been consistent relatively over the past few years as well. The first being member communications remain critical, especially on design elements and key dates. Second being that pensions continue to lend themselves well to class action proceedings. Third, that surplus entitlement remains a live issue. Fourth, that pension governance is increasingly exposed to political scrutiny. And 5, collective bargaining pension disputes continue to generate significant case law. Next slide, please. So the last 2 cases we have are more benefits oriented. So the first one is labor arbitration between Hydro One and the Society of United Workers, their union, about prescription drug coverage under the collective agreement. The union argued that Hydro One, through Green Shield, was only reimbursing members for the lowest cost generic drug, even though the benefit plan language only referenced mandatory generic substitution and did not expressly limit coverage to the lowest cost generic. The benefit brochure, which was incorporated into the collective agreement, became a key issue as to whether or not Hydro One's reimbursement practice was consistent with the negotiated language. Next slide, please. The arbiter allowed the grievance. He found that the plan clearly required generic substitution for brand name drugs, but did not clearly say the reimbursement was limited to the lowest cost generic alternative. Because this extra limitation was not stated in the negotiated plan language, Hydro One was found to have violated the collective agreement. The arbitrator ordered Hydro One to direct Green Shield to reimburse prescribed generic substitutions and to compensate affected members retroactive to January 25th, 2024. Key takeaway here is that claim administration practices cannot add restrictions that are not in the governing documents themselves. Next slide, please. So the last case we have is an interest arbitration between the City of Vaughan and the City of Vaughan Firefighter Association after their collective agreement expired in December 31st, 2023. As a bit of background, because the firefighters are an essential service, there is no right to strike or log out. The unresolved bargaining issues had to be settled through arbitration. The central issue in this dispute was when the employer attempted to eliminate lifetime retiree benefits and replace them with a healthcare spending account. The city argued that the lifetime benefits were not a sector norm and were costly. When the union argued, on the other hand, that the existing negotiated right should have not been removed without something meaningful in return. Evidence showed that while other municipalities had similar benefits that were removed, such changes were often achieved through bargaining or some significant offset value. Next slide, please. The arbitrator rejected the city's proposal to remove the lifetime retiree benefits and accepted that those benefits were unusual in the sector, but the replication of matching comparator agreements was not done mechanically. Her point was that the major bargaining changes usually happen incrementally or typically in exchange for something else, or because of a special circumstance such as harmonization or a specific trade-off. Those features existed in the comparator cases that the city relied on, but were not present in their own facts. The takeaway from this is that long-standing retiree benefits are difficult to remove without meaningful trade-offs. Next slide, please. Finally, to wrap this off, some benefit legal issues to watch. So again, we're highlighting 5 here. The first being that human rights and charter challenges remain active components of benefit case law. The second being that cybersecurity and governance continue to matter. The third, that document hierarchy and contractual interpretation remain central. Or that collective bargaining settings continue to generate significant disputes. And then finally, the funding structure matters, especially where benefits are administered through administrative services only agreements. That's everything I have on case law. I'm going to turn it over to Michael Wolpert again, who will discuss annuities.
Thank you, Carter. As Johnny mentioned earlier, Alberta recently introduced some legislation pertaining to statutory discharges for annuity purchases. If we could, thank you for getting the first slide. And this was actually a long time coming. Alberta actually introduced this legislation, I don't know, probably 15 years ago, and it failed a few times, and finally they've got it through. So it now enables pension plan administrators to discharge their liabilities through a transfer of assets to purchase annuities, subject to the legislation and the regulations. It's not enforced yet because the amendments to the regulations are still required to implement this change. And the discharge will be broadly available for annuity contracts purchased for deferred members, surviving pension partners, active members who've ceased accrual but are still under the DB provision but are still in the plan, and individuals already receiving a pension under the DB provision, so retirees. Regulations are currently under discussion, and the regulator's been quite open about getting input. I think they'll be fairly relaxed. They seem to be inclined to introduce retroactivity. So in other words, if you'd purchased annuities, I don't know, 10 years ago or 5 years ago, they'll all be covered under the statutory discharge. And I think they may not look for any kind of actuarial certificate. It'll be fairly relaxed with expectation that administrators will do whatever they need to do to get the annuities properly in place. So next slide, please. Annuity purchases are still going strong. They were quiet for many, many years after defined benefit provisions started to close. A lot of sponsors started to de-risk their plans, but because interest rates were low or zero, annuities were quite expensive. So it was sort of an interim measure that many of them took steps to change their asset structure to reduce volatility and dependence on equities and just sort of stabilize. And then when interest rates went up, annuities started being purchased, and the market's been quite busy. It's a rough estimate that we can't get exact details, but somewhere around $7 billion in risk transfer via annuity buy-ins and buyouts in Canada in 2025. And the market appears to be as strong or stronger in 2026, certainly based on our own experience. So next slide, please. Process issues are still a concern from our perspective. The purchase process and the associated timing is very tightly controlled. It's the actuary consulting firms typically go out in certain windows and reach out to insurers to see who's interested in bidding on certain plans that are looking to annuitize. And in many cases, they may not bid because they're already too busy, they're too full. They have to be in a position to have assets there to back those annuities if they're going to bid under their own regulations. So But the point being, I think because the timing is so tightly controlled, often there's limited opportunity for legal input, and in many cases, not until after a letter of commitment has been signed. In other words, the contract is effectively in place between the administrator and the insurance company. And there's really sort of three sort of key documents that play a role here. There's the initial request for quotations, or RFQ as it's often known. The bid acceptance letter or application, it varies by name, and that's sort of the relatively brief document where the administrator has decided on a particular insurer and the bid, and they make that formal commitment, and in effect the deal is in place. And then the annuity policies themselves, which are really entered into sort of after the fact in a way, and over a fair period of time in some cases. As well, in some circumstances, plan documents and trust agreements may need to be amended or at least reviewed prior to annuitization. So one more slide, please. It's really important that the RFQ and the contract, so that's the annuity contract itself, accurately reflect the plan terms. That's extremely important in terms of discharging liability, both from a standpoint of the statutory discharge, also for tax reasons, and to reflect the commitment that the plan sponsor made to members. So in essence, the annuity is taking the place of certainly with a buyout annuity, the annuity is taking the place of the promise that was made under the plan with respect to pension benefits, and all financial and legal liability is transferred to the insurer. So as a result, the communications to members that go out in respect of an annuity are extremely critical and need to be reviewed from a legal standpoint, at least from our perspective. And keep in mind that each insurer has its own standard form set of documents. In many cases, we're asked to review those ahead of time so that organizations or administrators can determine what those documents say, because they all have different provisions, different levels of risk, and that comes into play during the provider selection process. And there's also differing approaches to revision and negotiation of the contracts. Some are quite quick and quite agreeable. Others take a stricter approach, and it may take months in some cases. It's a bit of an unusual process where, as I mentioned, the contract is effectively in place, but the sort of, it's not papered until months later. But in our experience, it's all done in good faith, and that's just the way the process works. The requirements for statutory discharge of liability vary by jurisdiction. We've just talked about Alberta, that's pending regulations, but rules are in place in BC, Ontario, Quebec, Nova Scotia, New Brunswick, and then also in Saskatchewan, but not in force, and federally pending regulations. And they're all slightly different. And if you have members in those provinces, you need to be aware of those requirements. Lastly, I'm just going to close with this, that annuity purchases are significant transactions, often in the hundreds of millions of dollars, and with major financial, HR, and legal risk implications, which in many instances may not come to light for many years later. So it's important that those risks be understood and managed at the time of annuity purchases and implementation. And from our perspective, there's value in early involvement and a very collaborative approach with the consultants and the insurers. And in our experience, that works well, and hopefully everybody is sort of satisfied at the end of the day that they've got sort of the best arrangement in place. So that effectively concludes the presentation, the formal part. We've come to the end of our time today. I'd like to thank our panel and our viewers for joining us today. You'll see information that's just been put up on your screen for CPD credits for Ontario, Quebec, and British Columbia, and links have also been added to the audience chat. So if you don't get a chance to claim your certificate today, they will be sent next week. Thank you for coming. And before we conclude, we do have time for a few quick questions. If there are any, I believe you can send them in. We did have one question that came in advance, and that sort of ties into what I was just talking about in part. How employers in Canada are phasing out of DB plans. Is it a practice to freeze for union employees in a bargaining process? And yes, I think employers are continuing to get out of the defined benefit space, but many of those processes were started quite a few years ago. In some cases, 10 to 20 years ago, especially in the energy industry. But those plans were in holding patterns for reasons that I mentioned. De-risking was put into place, but now they're starting to annuitize and to wind up those plans. There does not appear to be a great deal of activity in terms of establishing new defined benefit plans. Partly, certainly we're seeing a bit of a chill due to changes to the Insolvency and Bankruptcy Act and the ability of plan sponsors to borrow money if they have or they establish a new defined benefit plan. And on the unionized front, we're seeing much more activity on that side and interest in pensions from unions. They're taking a harder line from my experience. They've become quite sophisticated in their ability to assess plans. And it's not simple. If there are collective agreements in place, there have been a number of fairly high-profile grievances and judicial reviews. In most cases, it just turns on the collective agreement and what's wording is in there, and it becomes a bargaining issue. So it's really all over the map, but it depends on how the plan has been integrated into the collective agreement. The only advice I would say is don't assume that you can go ahead and close off a DB plan without some pushback. So it does not appear that any other questions have come in. So once again, thank you very much. Appreciate your time. So enjoy the rest of your day. Thank you very much, everyone. Bye-bye.